Well, welcome again, everybody. I'm Chandra Andrade, and my colleague Rebecca Stevens is also here. And today we're going to be talking about how to prepare your wine business for the slate of new 2022 employment laws. And as part of our presentation today, we're going to cover kind of two halves. The first half, legislative and judicial changes that came out of the late fall 2021 legislative session, with a lot of new laws taking effect in January of 2022. So already under operation, if you will. And so we'll cover a lot of those new changes and how they can affect you and particularly your wine business. And then we'll turn to quite a bit of detail about COVID-19 and some prevention practices and requirements, some changes effective in January and February, including as recent as today, and also just look at some kind of past practices and existing requirements that continue into 2022.
Okay, so moving on to the next slide. Starting off today with some updates that everyone will have to make to template employment documents that they're using with workers. Just a quick overview of this, these changes are largely coming out of the Me Too movement. So we're still seeing new laws being passed in response to the Me Too movement from a couple of years ago. And the main changes this year are really aimed at confidential settlement agreements and confidential separation agreements, really limiting the extent to which employers can require employees to keep information about their employment and particularly unlawful acts in the workplace confidential, even when it's part of a settlement. And then we'll also be talking about some changes in the arbitration agreement context. If anyone's been following that, there's been a lot of litigation about that issue, and actually a recent federal law that was just passed a couple of days ago that will make some changes in that regard. So moving on to the next slide. Just as a quick reminder, existing law in California, which went into effect a couple of years ago, had already prohibited confidentiality provisions in settlement agreements that would prevent the employee from disclosing factual information relating to sexual assault, sexual harassment, workplace harassment, or discrimination based on sex, and any retaliation for reporting sexual harassment or gender-based discrimination. And again, you can see that that's quite clearly tied to the Me Too movement that was passed a couple of years ago. Next slide. This year, there's a new law that came out that actually further limits confidentiality in settlement agreements. And now, whereas the law previously only prohibited confidentiality relating to sexual harassment and sex discrimination, now that's been expanded so that you can't have any confidentiality provision in a settlement agreement that would prevent the employee from discussing any type of harassment or discrimination based on any protected characteristics. So race, national origin, disability, sexual orientation, any of those protected characteristics under the law, even if you settle a claim with an employee or a former employee, they still have to be able to discuss the underlying facts of those claims. And similarly, the retaliation piece has also been expanded to cover any type of retaliation for reporting harassment or discrimination based on any protected characteristic. Now, a couple of key pieces of this law, this only applies to a settlement agreement that's related to a claim that's been filed in a civil action with a state agency, in arbitration, anything that's already been filed. This section does not apply to any kind of pre-litigation demand that's been settled. So if you get a demand letter from an employee or a former employee, you reach a settlement, you still can have a confidentiality provision in that agreement. A couple other pieces that were already in the law, the employee can request a provision that would shield the identity of the claimant and any facts that could lead to the discovery of the identity of the claimant, but the employer cannot elect that. It's at the employee's election. And this provision does not prevent the confidentiality of the settlement amount. So even though the employee still has to be able to discuss the underlying facts, you can require that the employee keeps the amount of the payment confidential. Next slide. So existing law going back to 2019 had also prevented employers from, as a condition of employment, including for a raise, a bonus, or continued employment, requiring employees to execute some sort of document releasing claims under the Fair Employment and Housing Act, preventing them from disclosing information about unlawful acts in the workplace, or signing a statement that they do not possess any claim or injury against the employer. So what we used to see before this law was enacted is that sometimes when an employee was getting like a retention bonus or some sort of other type of bonus or a raise, the employer might ask them to sign an agreement in connection with receiving that payment saying you're waiving any claims that have accrued up till now, or you're signing something saying that you don't have any claims against the employer. That was outlawed as of January 1st, 2019. And so moving forward onto the next slide, there's been some further changes with respect to that. And particularly this law has now been amended to also include separation agreements. So it's pretty common in the employment context for an employee that's being terminated for performance or being laid off to get a separation agreement from the employer that offers some kind of a payment in exchange for them signing a release of claims. And now in the context of separation agreements, there's this new prohibition that says you can't have an employee sign a non-disparagement provision that would prevent them from discussing unlawful acts that occurred in the workplace. And if the employer is asking the employee to sign a separation agreement that includes some kind of non-disparagement provision, you have to include a carve-out that says nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you believe is unlawful. So note that this is actually much broader than the prohibition we just talked about in settlement agreements, because this allows employees to discuss any conduct that they believe is unlawful. Doesn't matter if it actually is unlawful, it's just what the employee believes. So this is pretty broad, and again, really limiting the extent to which you can have employees sign these confidentiality provisions or non-disparagement provisions, particularly if it would prevent them from talking about unlawful acts that happened in the workplace. Next slide. A couple of other changes here. If you're offering an employee a separation agreement, the agreement now has to state that the employee has the right to consult an attorney, and you have to allow the employee a reasonable time, which is defined as at least 5 business days, to consult with an attorney. The employee can decide to sign earlier than 5 business days, but they have to be given the option of waiting that full amount of time. And the decision to sign earlier has to be through their own knowing and voluntary decision and can't be sort of coerced by the employer. Again, employers can still require confidentiality of the payment amount in connection with the separation agreement, and the agreement can still protect trade secrets, proprietary information, or other confidential information, as long as it does not prohibit the employee from talking about unlawful acts in the workplace. Next slide. So a couple of key takeaways from these changes. Separation agreements and settlement agreements can still require the employee to keep the payment amount confidential. But keep in mind that a couple of years ago, there was a federal law passed that prohibits employers from taking a tax deduction for settlement payments related to sexual harassment if they're requiring the employee to keep it confidential. So just something to keep in mind when you're negotiating agreements with employees, lots of different factors to consider. I will say, most employers that I've seen have wanted the payment amount to be confidential, even if they won't be able to take the tax deduction. And as discussed, there are now severe limitations on the confidentiality of information relating to unlawful conduct. So in settlement agreements of a filed claim, there can be no confidentiality of the facts underlying any kind of sexual assault, harassment, discrimination, or retaliation claim. And then any kind of agreement in connection with a raise, a bonus, or a separation agreement, or as a condition of employment or continued employment, you can't require the employee to keep unlawful acts in the workplace confidential. There is still an open question about whether you can have confidentiality provisions and non-disparagement provisions in a settlement agreement where the claim hasn't been filed. So if you get a demand letter from a former employee or a current employee, and you're asking them to sign a settlement agreement in connection with those claims, it's not quite clear whether you can ask them to maintain the confidentiality of the underlying facts. That might turn on whether it's considered an agreement related to the employee's separation from employment, or whether the claim was resolved through the employer's internal dispute process, because there is an exception for allowing for confidentiality where the claim was resolved through the employer's internal dispute process. And I think this is still an open question that may need to be resolved by the courts or the legislature. But I will say we've had a few plaintiffs' attorneys take the position that a pre-litigation demand alleging wrongful termination, if there's a settlement agreement there, it's considered an agreement related to separation from employment. And then they say, well, we're not going to sign any kind of confidentiality provision. So it's just, that one's still open for debate. Next slide. A couple of updates with regard to arbitration. Some of you may recall that a couple of years ago, there was a law passed in California that banned employers from requiring mandatory arbitration as a condition of employment, continued employment, or the receipt of an employment-related benefit. And again, this was related to the Me Too movement. A lot of advocates for workers and employees, were complaining about the confidential resolution process in arbitration, denying victims of sexual harassment, sexual assault, the ability to have a public remedy for the claims that they were asserting. They wanted to be able to file in court, and they felt that arbitration was kind of concealing the bad acts and the bad actors from the public. This law in California did not take effect because the U.S. Chamber of Commerce challenged it in federal court, saying that it conflicted with the Federal Arbitration Act, which is a federal law that has a broad public policy allowing for the enforcement of arbitration agreements. So basically, the argument was that this California state law conflicted with the federal law, and because the federal law, kind of overrides that, the state law should not be enforced. A federal U.S. district court agreed with that argument and issued an injunction that prevented that California law from taking effect. But this past year in September, the Ninth Circuit reversed the district court, finding that the state law did not actually conflict with the Federal Arbitration Act because it focused on the voluntary nature of the formation of the arbitration agreement, but didn't interfere with the enforcement of any valid arbitration agreements. Litigation is continuing on this issue. The U.S. Chamber of Commerce has requested an en banc hearing by the Ninth Circuit. We also expect that, regardless of what happens with the Ninth Circuit, it's going to be appealed to the U.S. Supreme Court. Litigation is going to continue from here. So it might be a couple of years before we get an answer as to whether this law can take effect. In the meantime, we've seen employers taking a variety of approaches. Some employers have decided to just eliminate arbitration agreements altogether. Some employers have decided that, they really think that the federal courts are going to prevent this state law from ever taking effect. And so they're just going to continue requiring mandatory arbitration. The risk there is that if this California law does someday take effect, it may invalidate any mandatory arbitration agreements that were entered into after January 1st, 2020. So those may be thrown out. And there may be some civil penalties associated with employers that continue to require mandatory arbitration. And then some employers have decided to just update their arbitration agreements to be voluntary, not mandatory. The key there is that it has to be an opt-in process. It can't be an opt-out in order to be considered voluntary. Of course, the risk with that approach is that the employees may not sign, and then you have some employees that agreed to arbitration, some that didn't, or maybe all of them don't. And so there's a lot of disparity across the workforce. One further update, just to make everything more complicated, just this past week, the U.S. Congress passed a bill that bans forced arbitration of sexual assault and sexual harassment claims, and basically says that employees have the ability to file those claims in court, even if they've signed an arbitration agreement. Basically, it would apply to any claim or dispute that accrues after this law takes effect, but it would apply to already existing arbitration agreements. So if you have employees that already signed an arbitration agreement, if this new law is signed into law by President Biden, the employees would still be able to file their claims in court rather than taking those claims to arbitration. And President Biden is expected to sign that bill into law in the near future. There's still an open question under this new law, actually many open questions because it's brand new. But one is, what would happen in a case where an employee is alleging various different claims? Maybe a sexual harassment claim, maybe also a race discrimination claim or some other type of claim. What would happen? Would all of the claims get to be filed in court? Would some of those claims be filed in court and then some in arbitration? So there's a lot of practical issues that, just aren't clear. But, once this law takes effect, I'm sure there will be lots more to learn and hear about it. Just a couple of quick updates to keep us moving along. Payment of arbitration fees and costs. There was a law passed a couple of years ago requiring employers to pay, if there is an arbitration agreement, have to pay all fees and costs within 30 days or else they're in material breach, and then the case can be refiled in court. Next slide. Sort of consistent with that law, there's a new law this year that requires arbitration providers to immediately provide an invoice for those fees once the requirements to initiate the arbitration have been met. And the arbitration provider cannot allow a payment deadline extension unless all the parties agree to it. All right.
Great. So another new law that took effect last month adds a parent-in-law to the list of family members or relatives for whom employees may use leave under the California Family Rights Act. So a couple of years ago, the CFRA, a different revision to the CFRA made it so that mandatory 12 work weeks of job-protected time off of work for eligible employees had to be provided by employers who have 5 or more employees. So the span of sizes of employers that need to be providing CFRA to eligible employees has expanded. And this law, effective this year, simply adds parent-in-law to the list of family members for whom someone can be eligible to take this kind of leave. We wanted to just quickly note that there were some other changes that were considered but not enacted this year. So AB 1041 would have allowed employees to take CFRA leave to care for a designated individual, whether or not that person was a family member, so perhaps a live-in boyfriend or girlfriend. And that bill was pulled before the final vote in the Senate, so don't need to worry about that for current purposes. And then another Assembly bill would have increased wage replacement rates for paid family leave benefits. So that's a state benefit for certain types of leave that could have been increased, but has not been, thanks to a veto by Governor Newsom. Next slide. So in terms of the DFEH mediation program, as some of you may recall, existing law required the Department of Fair Employment and Housing, which administers civil rights actions and enforcement in regard to Fair Employment and Housing Act type claims, discrimination, harassment, et cetera. Existing law required the department to create a small employer family leave mediation pilot program for alleged violations of family care and medical leave provisions. And this program was applicable to employers that were smaller, so between 5 and 19 employees, many of which size may apply to many of you on this webinar. And existing law also required or authorized the employer or the employee to request all parties to participate in a mediation through this dispute resolution process. And so basically what this new law, AB 1033, does is it recasts these provisions to require the department, whenever an employee requests an immediate right to sue alleging a violation of family care and medical leave, to notify the employer in writing of the requirement for mediation prior to filing a civil action. And so essentially this is encouraging claims that employees may bring asserting discrimination, harassment in regard to family leave issues. It basically tries to route those types of claims for smaller employers into the mediation process, which is perceived to be a little bit lower cost, a little bit less time consuming than full-fledged litigation over these types of claims. So it's seen as a sort of benefit to smaller employers like many of you on this call. Next slide. So we just wanted to call out here, there's no action items coming out of AB 73, but this existing law had already required the California Department of Public Health to establish a stockpile of personal protective equipment to supply to essential workers during a health emergency. And so this new law just expanded the definition of essential workers for whom this PPE needs to be provided in the stockpile to include agricultural workers, and as well as health emergency now includes wildfire smoke events, which are obviously becoming more prevalent in California. So just wanted to call this out for folks in the wine business who have agricultural workers, that now this new law is going to ensure that there's a stockpile of PPE to cover essential workers, including the agricultural folks. Next slide. So on personnel records and notices, as most of you are aware, existing law requires certain workplace rights and obligations to be posted at the physical work site. And what AB 657 does is provide that in any instance where an employer is required to physically post this kind of information, the employer may also distribute the information to employees by email with a document or the documents attached. It's kind of a new thing, but not really a new thing, because the law basically says you can do that, but you also have to still physically post the posters. So it's not a huge change in requirement, but does allow that electronic distribution, especially for employees who may be hybrid or fully working remote. So Senate Bill 807, this is one affecting, back to the previous slide, please. This one, oh, I'm sorry, yeah, we're still on the right one. So this one covers personnel records for applicants and employees. It used to be that the time to retain these types of records was required to be 2 years. And so this law expands that time period for employers to have to maintain records of its applicants and employees to 4 years. So that's the doubling of the amount of time. So just be aware and be mindful of making sure that you're preserving your employment records for both applicants and employees. Next slide. This is a kind of interesting law. So SB 639, also effective January 2022, addresses an outdated federal policy that some of you may have been aware of. It dates back to the 1930s, which basically allowed employers who secured a special certificate to pay people with disabilities under the minimum wage. The number of employers in California trying to get these certificates has continued to drop over time, but the practice still, until this year, remains legal. And so what SB 639 does is it prohibits any new such licenses from being issued, and then will phase out licenses over the course of 3 years. And so ultimately by January 1st, 2025, it will be illegal to pay any employee with disabilities less than the minimum wage, regardless of licensure status. Next slide. So a heads up on minimum wage, they're constantly changing. And effective January 1st, 2022, the state minimum wage has in fact increased. So that there's difference in depending on employer size. If you have 25 or fewer employees, the California state minimum wage is now $14 per hour. And if you have 26 or more employees, the minimum wage is $15 an hour. We do want to point out for a lot of you clients that this minimum wage increase also impacts the threshold requirement for salary if you're going to be trying to classify employees as exempt or non-exempt. And so for any employee to be classified as exempt now, that for employers with 25 or fewer employees, they need to be earning a salary of at least $58,240 a year. And for employers with 26 or more, the minimum salary for exempt classification is $62,400. We also should point out that many cities and counties have their own minimum wage. So if you're in any of these cities, you want to be careful that you're applying the minimum wage to your workers. That's most favorable to the workers. So in these cases, these minimum wages will apply if your business is in any of these cities. AB 1003, also effective in January. So this new law essentially underscores the state's continued and quite intense focus on the proper payment of wages by including significant criminal penalties for employers who commit so-called wage theft. And wage theft sounds like a crime. It's basically failure to pay overtime, failing to pay minimum wage, like we just talked about, allowing off-the-clock work, not giving employees meal and rest breaks. So any sort of intentional failure to properly pay wages can now subject employers to these criminal penalties. This law actually adds a section to the California Penal Code, which says that intentional theft of wages of an amount greater than $950 for a single employee and $2,350 in the aggregate for 2 or more employees in any consecutive 12-month period may be punished as grand theft. I should point out too that AB 1003 clarifies that for purposes of this new law, employee actually includes an independent contractor. So be mindful that wage theft now is a consideration, and you need to follow wage payment and your minimum agreements to pay wages to your independent contractors as well as to your employees. Last thing real quick on AB 1003 is that this is really a motivation, if you will, for employers to perhaps undertake some sort of wage audit. You can engage counsel or just have your accounting department take a pretty hard look at your practices, make sure that you're up to date and properly paying folks their wages, breaks, overtime, et cetera, to try to avoid running afoul of this new criminal penalty. Next slide.
All right, well, now turning to the topic that I think has brought many of you here, which continues to develop and evolve and be complicated and confusing for everybody, COVID-19. So first, just to start off, what are the rules that apply to your business? Well, the big one is Cal OSHA's COVID-19 Emergency Temporary Standards, which remain in effect for all employers of any size. We often get questions, I only have 5 employees, I only have 3 employees, do I have to comply with this? These emergency temporary standards do not differentiate depending on employer size, but there are a few exceptions. So one is if you have a work location where there's only 1 employee that does not have contact with other people, the rules would not apply there. If your workforce is primarily working from home, or for any employees that are working from home, those standards don't apply to them. Any employees that are working at a location that was chosen by the employee that's not under the control of the employer, so teleworking from a cafe or a library or something like that. And then employees that are covered by the aerosol transmissible diseases regulation, but those are typically employers that are in the medical field. So probably not any of you would be covered by that exception. But if you don't fall under any of these exceptions, then you are required to comply with Cal OSHA's emergency temporary standards. The other piece is that employers have to follow the California Department of Public Health orders, which in the past have sometimes conflicted with Cal OSHA's orders, so that makes it confusing. And then, of course, any public health orders that were issued by your county or city, we've definitely seen sort of a patchwork across the state of, different counties, different cities having rules that differ from the state rules or that differ from other county rules. So lots to keep track of. Next slide. So the main thing coming out of these Cal OSHA emergency temporary standards is the requirement for employers to have a COVID-19 prevention program. And that is still required to this day. Each employer has to have a written COVID-19 prevention program that addresses this entire list of factors, telling employees about the employer's prevention procedures. It will have to have processes in place to identify, evaluate, and correct COVID-19 hazards. In the plan, you have to explain how you're going to do that. The employer has to require and provide face coverings and respirators as stated in Cal OSHA standards. Employees have to be advised that they are allowed to wear masks at work regardless of their vaccination status, and that retaliation against an employee for affirmatively wanting to wear a mask is illegal. The plan also has to describe engineering controls, administrative controls, and PPE under certain circumstances. So, for example, what type of ventilation is in place? Is there any sort of air filtration? That kind of stuff has to be addressed in the plan. There have to be procedures in the plan to investigate and respond to COVID-19 cases in the workplace. So you have to explain how you're going to do that if an employee notifies you of a positive test result and they've been in the workplace. What are you going to do to investigate that and address it? The plan also requires that employers provide COVID-19 training to employees about all of these topics. In general, the training just needs to cover the same topics that are addressed in the program, but there has to actually be a training. Cal OSHA is developing trainings that employers can use for this purpose, but I checked their website yesterday and the trainings are still not available. So not super helpful while employers are currently required to do all of this stuff to not have that stuff available. The plan also needs to explain to employees that testing is available to them at no cost if they've had a close contact in the workplace, or if there have been multiple infections or a major outbreak in the workplace. Free testing has to be available on a regular basis. The plan also has to explain how positive cases of COVID will be excluded from the workplace. The plan has to comply with all of the return to work criteria that's been established by the California Department of Public Health and Cal OSHA. And then the plan has to explain how employers will maintain records of COVID-19 cases and report serious illnesses to the agencies that have to receive those reports. So lots of information to be put in the plan, lots of thinking to be done about what you're going to do to address all these topics. I will say that Cal OSHA has developed a model COVID-19 prevention program that's available on its website. It's got all of these required elements in it, and you just kind of fill in the blanks for your specific workplace, what the details are. Most of our clients have been at least using that template program as a starting point, just because it has everything in it, and make sure that you have all the required information. Next slide. The Cal OSHA's emergency temporary standards were just updated last month. They were issued last year, and they've been pretty consistently and regularly updated. A couple of the changes that came into place last month is that a COVID-19 test now includes instructions for workers doing a test at home with self-read results. So previously, the definition of a COVID-19 test, including the type of test that an employer would have to offer at no cost, it previously had to be a PCR test. And now there's an option to have employees use a self-test at home. The complicating factor, though, for this is that the employer or a telehealth professional has to actually observe the use of the test. So for many employers, especially smaller employers, this may not really be a viable option. Do you really want to ask somebody to be on Zoom with your employee, watching them take a test and, confirming that they're following all the instructions? It may just be better to use a PCR test or something like that instead. The definition of face covering has also been updated to include more detail on the acceptable types of face coverings. And the definition of fully vaccinated has now been updated to include the minimum amount of time that workers have to wait between the first and second dose of a 2-dose vaccine in order to be considered fully vaccinated. The testing piece has been updated as well. So now it used to be under the old standards that testing only had to be made available to unvaccinated employees after a close contact in the workplace. The new update says that testing has to be made available to fully vaccinated employees as well if they've had a close contact in the workplace. So that's actually a pretty significant change. And then during an outbreak, which is defined as 3 or more positive cases in a 14-day span in the same work site, the employer has to make COVID-19 testing available regardless of vaccination status on a weekly basis or twice per week during a major outbreak. And then lastly, on the face coverings front, fully vaccinated employees now have to wear face coverings if they're in transportation that's provided by the employer. So constantly changing. Next slide. So starting with face coverings, employers must provide employees who are not fully vaccinated with face coverings and ensure that they're properly worn over the nose and mouth when indoors and in vehicles. And that's been the rule since last year. That hasn't changed. Outdoors, employees do not need to wear face coverings regardless of their vaccination status unless there's an outbreak. Employers also have to provide and ensure the use of face coverings by employees when it's required by the California Department of Public Health, when an employee had COVID-19 or had close contact with a COVID-19 case and returns to work, or when riding an employer-provided motor vehicle transportation. Next slide. The exceptions to the requirement of face coverings include when an employee is alone or in a room in a vehicle, while the employee is eating or drinking, as long as they're 6 feet apart or outside. Employees that are wearing respirators, which are those N95 masks that actually have like a vent, they don't have to wear a face covering over that. Employees who can't wear face coverings due to any kind of disability or medical condition or mental health condition, or employees who are hearing impaired or communicating with a hearing impaired person, or if they're doing a task that just can't be performed while wearing a face covering, they don't have to wear them. And employers also have to provide face coverings to employees upon request, regardless of vaccination status. So, you may have employees that are vaccinated who want to wear face coverings. You have to provide it in those circumstances, and the standards are clear that there can be no retaliation against an employee who affirmatively chooses to wear a face covering, even if they're not required. One update that went into effect today, the California Department of Public Health has lifted the indoor mask requirement for vaccinated individuals. So that's one thing that's changed today. Employers are still allowed to require indoor mask wearing if they choose to. And that goes for employees and patrons. I'm sure many of you have tasting rooms or public facing operations. And so you are not required to have people wear the face coverings, but you can choose to if you want to. Next slide. Oh yeah, so these are the updates. Effective today, universal masking is only required in certain specified settings. Only unvaccinated people are required to wear masks in indoor public settings and businesses. And then fully vaccinated individuals are recommended, but not required, to continue wearing masks indoors where the risk can be high. And then the following is the list of exceptions to this, this requirement being lifted. So masks are required for everyone indoors on public transit, indoor in like childcare and school settings, in emergency shelters and cooling and heating centers, healthcare settings, state and local correctional facilities and detention centers, homeless shelters, and then long-term care facilities. Next slide. Okay, so the vaccine issue, some of you may have been following the federal rules on this that have evolved over the last several months. You may recall that the Biden administration, federal OSHA, had issued a rule stating that all businesses with 100 or more employees would have to mandate vaccination for their employees. That has been struck down by the courts, so that's not in place anymore. And California does not have a vaccination requirement for employees. So employers may require employees to receive a vaccination against COVID-19 as long as they don't discriminate or harass employees or applicants on the basis of a protected characteristic, provide reasonable accommodations for disabilities or religious beliefs, and don't retaliate against anyone for engaging in protected activities such as requesting a reasonable accommodation. We've seen a lot of activity over the last several months in this area. Some employers have been issuing vaccination requirements. We've seen a lot of employees requesting accommodations, saying that they can't get vaccinated because of a medical condition, because of a disability, because of a religious belief. And that's just been a very hot area in employment law. Just lots of new issues coming out every day with that. But the key is, federal and state law does require reasonable accommodations for employees with disabilities and employees with sincerely held religious beliefs. So if you do have a vaccination requirement and you have an employee that's requesting an accommodation to be exempted from that, make sure you think carefully and probably consult with counsel about how to proceed, because those are just tricky issues. Employers still may require employees and applicants to submit proof of vaccination. Employers can instruct their employees and applicants to omit any private medical information from that documentation. If you do collect that information from your employees, it has to be maintained as a confidential medical record. If you don't want to ask about vaccination, then you have to treat all employees as unvaccinated in the workplace. So the California standards have sort of come out with no requirements of having everyone get vaccinated. But the emergency temporary standards do require employers to encourage employees to get vaccinated. One of the components of the COVID-19 prevention program is that you have to explain to employees the benefits of being vaccinated and that it can help reduce the transmission of COVID and kind of encourage people to get vaccinated. And then the other key piece, as I just noted, is that if you don't have a vaccination requirement and you're not collecting information about who is vaccinated, then you have to treat everybody as unvaccinated, which means everybody has to wear masks, everybody has to follow all of those precautions that are in place for unvaccinated workers. Next slide. If you have a COVID-19 case in the workplace, you do have to investigate and respond to it. You have to determine when they were last in the workplace, when they were tested, the onset of symptoms. You have to determine which employees may have been exposed through a close contact with that person. And you have to provide written notification to anyone who was at the worksite at the same time as that person during the high-risk exposure period within 1 business day. Keep in mind that the notification, you still have to maintain confidentiality and privacy of the individual that tested positive. So you wouldn't include their name or any identifying information, but you would have to let people know you may have been exposed, you may have had a close contact. Next slide. In addition, if you have a COVID-19 case in the workplace, you have to make COVID-19 testing available to anyone who was potentially exposed at no cost during working hours. And then you have to exclude anyone who was in close contact with the positive case from the workplace. And then you have to investigate the exposure, including whether workplace conditions could have contributed to the risk and what corrections might reduce the risk going forward. Close contact for these purposes is defined as being within 6 feet of a COVID-19 case for a total of 15 minutes or more in any 24-hour period during the high-risk exposure period, which is generally 1 to 2 days before the onset of symptoms. And then, of course, while they were testing positive, usually about 5 days after they first had symptoms. Next slide.
So now we're going to turn to isolation, quarantining, and returning to work. So you may all have somewhat confusion around this because there has been a variety of different guidance on how long are people supposed to isolate, how long are people supposed to quarantine, is it 5 days, is it 10 days? And the reason for that confusion is that the different sort of regulatory bodies have come out in different ways on this. To try to alleviate some of that confusion, in December of 2020, Governor Newsom issued an executive order which basically said that the recommended isolation and quarantine periods for purposes of the Cal-OSHA ETS are going to be necessarily overridden by any applicable periods recommended by the California Department of Health if the periods in the ETS are longer than those recommended by the California Department of Health. So in other words, Governor Newsom has expressed that Cal-OSHA should basically defer to shorter isolation and quarantine periods if advised by the Department of Public Health. And then meanwhile, there's also the federal CDC and their guidelines. And fortunately, in December of 2021, the California Department of Health decided to follow the federal CDC guidance around these requirements. So this is all to say we now do have some pretty clear guidance on the respective quarantine isolation periods, and it actually is very specific. You can see on this slide, the requirements and the time periods and the different factors that go into how long people are going to be required to isolate and quarantine. So as a quick reminder in terms of isolation applies if you're sick or you test positive, even if you don't have symptoms. So it's a little bit tighter restriction. And then quarantining applies if you are exposed to the virus. And so this slide talks about exclusion requirements, in other words, isolation requirements for employees who test positive. And so on the slide, you'll see that there are requirements that apply to all employees, regardless of vaccination status, if you've had COVID-19 before or any lack of symptoms. And essentially what this boils down to is everyone, regardless of vaccination status, can return to work after day 5 if symptoms are not present and there's a negative test. And then there's an additional 5 days isolation if the person's symptomatic after day 5, or if the employee is unable to, for some reason, or chooses not to test. And then there's some masking requirements that come after the isolation period. Effectively, you're supposed to wear masks around others for 10 days after the positive test, especially while indoors. If you could turn to the next slide. So this talks about quarantine. And so quarantining requirements for folks who are not positive, are asymptomatic potentially, and who have, and so folks who essentially had close contact with somebody who had COVID-19, but not necessarily tested positive themselves, in which case quarantine requirements apply. And as you'll see on this slide and the next, the requirements differ depending on if the employee was unvaccinated or vaccinated and booster eligible, but not yet received their booster dose. And on the next slide, we'll look at the requirements, which are a little bit more lax for those who have been fully updated on their vaccinations. So quickly back to the prior slide, please, just to kind of quickly tick off the requirements for those employees who are unvaccinated or not up to date on their vaccinations. In the event of an exposure to COVID-19, they need to be excluded from the workplace 4 or 5 days after their last close contact. And the exposed employees must then test on day 5, and quarantine can then end, and the employee can return to the workplace after day 5 if the symptoms are not present and a diagnostic specimen collected on day 5 or later tests negative. So slightly more restrictive requirements in the case of unvaccinated folks in terms of quarantining. So then turning to the next slide, these are the slightly more relaxed requirements for those who are unvaccinated or who are up to date on their vaccinations and have been exposed to COVID-19. So for these folks, they must be excluded from the workplace for at least 5 days after the last close contact with the person. And then essentially you don't have to quarantine at all. You just have to test on day 5. And then the other requirements can apply. You might go back to the first slide on isolation if the person tests positive, et cetera. So let's turn to exclusion pay. This is a kind of sore point for many employers. What Cal OSHA did with its ETS is mandate that employers provide pay and benefits to employees who are unable to come to work because of Cal OSHA's expectations around quarantining and isolation. So folks who are excluded from the workplace because of COVID-19, and specifically because of a COVID-19 exposure in the workplace. So here we're talking about exclusion pay. In a second, we'll turn to supplemental paid sick leave, which applies to any type of COVID-19 exposure, whether it's at the workplace or not. But for the purposes of this slide, only for employees who are excluded from the workplace because of COVID-19 exposure that they got at work. And essentially the employer has to continue to pay them their normal pay rate and benefits as long as the employee is not able to just telework during the time that they're out of the office, in which case you don't have to pay them extra, you just pay them their normal wages. And you're not required to pay exclusion pay to folks who are receiving disability payments or workers' comp benefits during the period of the exclusion. There is some ability to offset exclusion pay through a generous PTO policy. And so I've had many clients ask whether they can require employees who are excluded due to workplace exposure to apply paid sick leave, which is all of you should know by now. Pre-COVID, there were laws that require all employers to provide some amount of paid sick leave to their employees. And so the answer here is that employers that provide a paid leave policy that is separate and in addition to the mandatory California paid sick leave policy may require their employees to use that separate sick leave as permitted by law. But the key point here is that you cannot require an employee to use their standard California required sick leave allotment for purposes of allotting to the exclusion pay. It's an additional benefit. Next slide, we talk about the other type of paid sick leave benefit I mentioned, supplemental paid sick leave. There's been a few iterations of this. There was a supplemental paid sick leave law that was in effect in 2021, which had since expired. And that supplemental paid sick leave law required that from January 1st, 2021 through September 30th, 2021, larger employers with 26 or more employees had to provide up to 80 hours of paid sick leave to folks who are unable to work or telework for COVID-19 related reasons, again, whether or not the COVID-19 exposure was at the workplace. So last week, Governor Newsom approved a measure that revives the statewide supplemental COVID-19 paid sick leave law, making it retroactive to January 1st, 2022, and again, in effect through the end of September. There's a couple differences between the 2022 iteration and last year's iteration. And in fact, the 2022 iteration has some sort of pro-employer and then pro-employee benefits distinctions, if you will. So in terms of the pro-employee benefits, the 2022 version makes clear that employers may not apply exclusion pay to cover this allotment. So under the 2021 benefit, employers were able to sort of correlate their exclusion pay and use that towards the paid sick leave, whereas with 2022 supplemental paid sick leave, you cannot do that. It's a supplemental benefit. And it's also clear that if an employee did not if an employee used their 2021 supplemental paid sick leave, that cannot be allocated to the 2022. It's an additional benefit whether or not people were able to take advantage of the 2021 sick leave. Just for a lot of folks on the call, just to clarify that the 2022 law also is only applicable to larger employees. So you don't have to worry about this if you have 25 or fewer employees. There's some kind of nuances here. I won't go into too much detail since we're running out of time, but there are, in terms of the employer-friendly distinctions with this law, there had been quite a bit of incidences where employees were kind of taking advantage of the paid sick leave by just staying home and submitting even fraudulent documentation to support the fact that they had COVID in order to get this free 2 weeks of leave. And so now there's in the 2022 version, they've separated it into a 40-hour bank for certain purposes, and then another 40-hour bank for other purposes. And there's more ability in there for employers to sort of go back and verify employees actually had COVID or that they were staying home to care for a family member with COVID. Next slide. Just to be aware, there, in addition to this kind of thicket of exclusion pay and supplemental paid sick leave, and over a couple of years now, there's also some individual citywide ordinances that also require some form of supplemental paid sick leave. So if you're in any of these cities, be aware that there may even be additional or even conflicting requirements at the ordinance level that you need to be aware of.
Okay, just a couple of final updates before we close out. SB 606 really relates to Cal OSHA's enforcement measures against employers that are violating Cal OSHA regulations. Keep in mind that this was sort of pushed through, I think, because of COVID, but it's not limited to just COVID. So this can be applied more broadly to any types of violations. And particularly, this law creates new categories of potential Cal OSHA employer violations, including enterprise-wide violations and egregious violations. We'll get into those definitions in a second. But each of these can lead to more penalties, more fines, more issues for employers if Cal OSHA makes a finding. And then also this law adds some additional enforcement tools for Cal OSHA, including allowing them to serve subpoenas, to apply for injunctions, get temporary restraining orders. So this really kind of beefs up Cal OSHA's enforcement ability in workplaces. Next slide. So egregious violations are defined as one of the following. The employer intentionally made no reasonable effort to eliminate a known violation, any sort of violation resulting in fatalities, 3 or more hospitalizations, or a large number of injuries or illnesses, a history of prior violations. These are the sort of factors that Cal OSHA would look for in assessing whether an employer had engaged in an egregious violation. So probably not talking about like a first-time violation of an OSHA rule, but if you have sort of an ongoing pattern, or if you have a lot of employees that are having the same issue, the OSHA may make this finding. And each instance that an employee is exposed to the violation would be considered a separate violation for purposes of issuing fines and penalties. So if you have one hazard that's not being corrected and OSHA finds that it's egregious, each time an employee is exposed to that one hazard will be a separate fine, a separate penalty. So it can really add up. Next slide. And then the other category here is enterprise-wide violations. So there's a rebuttable presumption that a health and safety violation by an employer with multiple work sites is enterprise-wide if either the employer's policy or procedure itself violates the Cal OSHA regulations, or if Cal OSHA has evidence of a pattern or practice of the same violation committed at more than one work site. If the employer is unable to rebut that presumption by showing that it's not an enterprise-wide issue, Cal OSHA can issue an enterprise-wide citation requiring abatement, and the penalty can be up to this very random number of $124,709 per violation. I don't know how they got to that number, but clearly it's pretty high, and so something to be aware of. Notably and helpfully, I think, with respect to COVID-19, Cal OSHA cannot find that there was an enterprise-wide violation if the policy was based on a rule that had been adopted within the last 30 days. So, obviously these Cal OSHA standards are constantly changing, they're constantly evolving. I think there's some recognition that it's challenging for employers to keep up with that. So that's why there's this little carve out. And then lastly, as I mentioned, the rule allows Cal OSHA to issue subpoenas if the employer fails to provide the requested policies and procedures promptly. So just creating more ability for Cal OSHA to go into court and get, court orders requiring things.
So we have a couple of questions in the chat that we'll tick off pretty quickly. Hi, Philip. Nice to see you. So you asked about wage theft and whether the employee or the former employee is required to prove if it was intentional versus unintentional. And the answer there is that this is a criminal penalty. So the government would be bringing the action under the penal code and would have to have the burden of proof on that to show that it was intentional. The bill does define intentional as through fraud and while knowing that the wages are due to the employee. And so, that's a pretty, fraud's a pretty big standard. It shows that you knowingly didn't pay folks. And a lot of employers are, in this great state, it's very easy to miss things and do things accidentally. And so the burden of proof will be on the government there. And the key thing is that you just, as employers, want to make sure that if you are aware of any issues with wages, unpaid overtime, et cetera, that you quickly address that and remedy it so as not to fall into this intentional versus unintentional trap. And then Rebecca Michael had a question on whether testing needs to be made available on site or if testing at the county or government level is acceptable.
Yeah, so I wrote the response in the chat, but the testing does not need to be available on site. You can refer somebody out for testing through another facility as long as the employer pays for any associated cost or pays for the time spent going to the test. And then I think there was one other question in the chat, just in case people didn't get to see it, about how would you determine whether guests are vaccinated or unvaccinated. There's not any requirement that businesses make that determination. They can choose to make that determination. Here in San Francisco, of course, we're seeing lots of businesses that are choosing to require that all guests be vaccinated. And the typical way that businesses would do that is either, asking the guests to show a copy of their vaccination card with an ID to prove that it's actually them. Or the state of California, at least for California residents, has this database of people that are vaccinated, and they can kind of go online and put in their information and get a QR code that the business can actually scan to confirm that the vaccination record is accurate for that person.
All right. Well, with that, I think that covers our questions that people did have questions on unvaccinated guests, which were answered correctly in the chat there. But with that, we thank you very much for your time.